reach your immigration goal. That's what we're doing today. Good morning, everyone. If you hear coughing in the background, it's because I have a sick child in the background. He's home from school today. Every parent can relate. Today's topic, I thought I would begin by creating a scenario that is very important to a lot of people. And that is, what do you do if you have an immigration case that involves a child and the child is about to turn 21 years old? This is a really, really important situation. And before we talk about the solution, you have to define the problem. The problem is that children are allowed to get immigration benefits so long as they meet the definition of a child under the Immigration and Nationality Act. And that requires children to be under the age of 21, under the age of 21 years old. If your child turns 21, the child is no longer a child. That's the problem. That is referred to among immigration lawyers and in the Immigration Act as aging out. So if you turn 21 years old, you age out. And aging out is not a good thing because you no longer meet the definition of a child. And that's bad. You're disqualified from the immigration case. The other way that a child could be disqualified is through marriage. If you have a child who's part of an immigration case and your child gets married, the child is no longer meets the definition of a child. So through marriage or through turning 21, you have aged out. And that means you don't qualify at all. The mistake that a lot of people make when it comes to children in their immigration case is they think that if they turn 21, it doesn't matter because they think incorrectly that what matters is that the child was 21 when the case was filed or when the visa petition was approved or when the interview took place or something like that. And they think that the child will be protected from aging out. And that is not the way it works. And you have to be under the age of 21 at the time of approval. And usually at this point in the conversation, people say, but Josh, what about the Child Status Protection Act? Let's talk about that for a second. So the Child Status Protection Act is designed, it's a mathematical formula that is designed to prevent some children from aging out, okay? You have to do a calculation and you have to figure this out. But what usually happens is that it does not protect children from aging out. And so it's disappointing. So people are always, whenever I say, listen, how old is your child? And they'll say, my child is 23, but when they went to the interview, he was 19. Well, the child is 23, 22, but when she went to the interview, when the visa petition was approved, she was only 20. They'll make these scenarios, and it often ends in tears and disappointments. And people actually get mad at me. They get mad at me for this. So I'm going to be talking more about children, but I'm also going to be taking whatever questions that you have about the Child Status Protection Act, about children, about anything else. I'm going to be taking questions from you and looking forward to seeing what I can do to help you reach your immigration goals. And joining us today is Halle, as always.
Hello, Josh. How are you doing?
Halle, is it my imagination, or do you have a new and amazing hairstyle today?
Oh my God, yes, actually.
Wow! I love it. I love it. That's amazing. You look great.
You're so nice. Thank you.
Well, thank you for joining us. And
thank you so much for having me today. I'm so glad that this is another great opportunity for applicants because when I was an applicant, I didn't have any access to a lawyer but now they have, and they can ask their questions directly from you.
Yeah.
I think it's very important to use this opportunity to, get your answers. I know it would be stressful when we have different questions and we don't know what is the next step.
So let me ask you this question. What do you think's on people's minds when they're trying to get a green card or a visa approved for their son or their daughter? What do you think people are wondering?
Yeah, actually, because um, they are far from their family, and the other hand, because of their unmarried cases, they are not allowed to get married. I think their concerns is double in comparison between other applicants, and I think it's very important to clarify the rules like the CSPA you just did, and to know what is important, how long they should be single, and lots of questions that I've already prepared for today.
Yeah. Well, let's get rid of a few of them right away. So the question is, how long should you be single? Well, you should be single until you have a green card or a visa. And what that means is that you have a visa in your hand, in your passport, that allows you to travel to the US. And then you get your green card. So if you have a green card, then you can go ahead and get married. Now, sometimes people have all sorts of questions about this. So, like, well, I'm not going to get married, but I just want to have a wedding. But we're not going to legally get married. We're just going to, sort of get engaged. We're going to have this engagement thing. Can I do that? No, because if the consulate somehow finds out that you have taken steps that indicate that you appear like you might be formally engaged, it could call into question whether you're actually single or not. And there's a lot of, sometimes people are like, no, the consulate denied me, but I'm not actually married. I'm only engaged to get married. And we had this big party with our families, da, da, da. And, it's always heartbreaking, but you're not going to, you just refrain from getting married until you have your green card. It's that simple.
Yeah, makes sense. And in actually, it's hard to do it because many of cases applicants with F2B or F1 cases are waiting more than maybe 6, 7 years to
Yeah.
be current. And
Well,
after being current, yeah,
well, I mean, when you think about how hard it is to refrain from getting married over a number of years, you have to weigh the cost and the benefits. The cost is that you're not allowed to get legally married, and that's something that you really want to do to formalize and express your love and your partnership um, with your loved one. That's the cost. The benefit is that you get a green card. So if you
yes,
don't want to get a green card, just go get married, no problem. But if you want the green card, refrain from getting married, and then after you get the green card, get married and petition for your spouse. Then you can,
yeah, makes sense.
yeah,
Actually,
it's
I
very
did.
simple.
Go ahead.
It's simple. It's not complicated. But let's go to the questions. What questions do you have for me today?
Of course, the first question is someone's case is EB1 and his case is at NBC and he's waiting for an interview. And the question is if one of the dependents get married, will he be eligible to get visa?
So the question that you asked is someone has an EB1 visa case, extraordinary ability, and they have a child dependent. The child dependent is waiting, and they're waiting to get their visa interview and to get processed. And the question is, can the child get married? Well, the answer is yes, the child can get married. However, the marriage would disqualify the child from getting a visa or a green card. So, yes, you can get married, but you should know that the marriage would disqualify them from the green card.
Yeah, yeah, it's very important to know that. Okay, just give me about a minute to translate
Yeah.
that. دوستمون پرسیدن که کیس ایشون EB1 هست و ایشون منتظر وقت مصاحبه هستن. کیسشون هنوز توی NBC هستش و پرسیدن که اگر یکی از دیپندنت ها که میتونه فرزند باشه ازدواج کنه آیا این کیس کنسل میشه؟ پاسخ این هستش که ایشون میتونن ازدواج کنن ولی دقیقا این باعث میشه که دیسکوالیفای بشن و دیگه مشمول در واقع این ویزا نباشن و نمیتونن از طریق کیس EB1 خانوادهشون ویزا بگیرن. Perfect. That's great.
So I had a great question on TikTok from Carrie. She says, do you recommend paper filing or e-file on their website? At this time, I recommend paper filing. So if you're filing with USCIS, I recommend that you print out the application, fill it out, and mail in the paper, just like, you know, the old days. Do not e-file. That's my general recommendation.
Oh, that's good to know that it's for all of the family-based cases as well.
Yes.
Oh,
here's another question from one of our friends on YouTube. Hi, I applied for a fiance visa about 2 years ago, and my fiance is under administrative processing for about 5 months. That's very disappointing. It shouldn't take 2 years to get this process sorted out, and no one should be stuck in administrative processing for 5 months. You basically have two options. One option is to continue waiting for administrative processing to be concluded. Administrative processing is a delay that happens after your visa interview is conducted. And one option is to wait for this to be concluded. The problem with that is that you don't know how long it will take for the administrative processing to wind up. It could take 6 months, it could take a year, it could take 2 years, it could take even longer than that. And that's the problem. The other way to get out of administrative processing, if you're sick and tired of waiting, is to contact us. We are experts at helping people get out of administrative processing. And the way that we help people is that we file a lawsuit against consulates and embassies around the world. We actually sue them. And the reason that we sue them is that the consulates and embassies and USCIS, they have a mandatory legal obligation to process immigration cases within a reasonable period of time. They can approve you, they can deny you, but what they can't do is make you wait and wait and wait and wait indefinitely. And that's what they often do. And when they do that, you can fight back and challenge them. So that's what we do to help, and that's what we can do to help you. Does it work in every single case? No, it doesn't. And when you contact us, we have a process where we review your scenario and try to determine whether your case would be a good fit for this. Here's another question that I liked. When is a good time to start a lawsuit? Well, that's a good question. The basis of a lawsuit to help you get your immigration case approved if you're delayed is that you have to have a case that has been unreasonably delayed. And the question is, what does it mean to be unreasonably delayed? How long do you have to wait? How long is too long? Would a year be enough? Would 6 months? Would 2 months? Does it start from the time you file the case or from the time that the interview happened? There's lots and lots of questions about this. The short answer is that we have criteria in our office that we use to determine whether we think that your case would be a good fit for this type of lawsuit. And if you schedule a free case evaluation with our team, we can let you know what we think. And if you qualify for representation, we will beg you to hire us because this is so effective. And if you don't, we'll tell you that directly. We don't want to take your case if you're going to get a bad result. Holly, why don't you hit me with some more questions?
Yeah, sure. The next question is, my mother is a green card holder and she applied for me 7 years ago. I've been waiting for too long. My question is, can I get engaged or my case will be canceled? I think you already answered.
Yeah, I'll repeat my answer because it's so important. Here's someone who's been waiting for a number of years to get their visa, and they want to get married. It's a very reasonable concern. The problem is if you get married, your immigration case will be canceled because you will no longer meet the definition of a child under the law. You will be considered, you will not be considered a child, and your immigration case will be canceled. Now, here we have a tricky person who's saying, okay, I'm not going to get married. I just want to get engaged to get married. And my answer would be don't do that, because if you do that, the consulate might think that you have gotten married or you have taken steps towards getting married. And then they say, but Josh, how would they know that I'm going to get engaged? You know, my advice is just to hold off. Wait till you get your green card, and then you can get married, you can get engaged, you can get your partner a green card or a visa. That's what I would recommend.
Yeah, perfect. دوست عزیزی پرسیدن که مادرشون برای ایشون 7 سال پیش اقدام کردن و ایشون منتظر مصاحبهشون هستن. پرسیدن که آیا توی این فاصله میتونن که نامزد کنن که به طور رسمی ازدواج نکنن، و پاسخ این هستش که اصلا کار توصیه نمیشه، چون اگر متوجه بشن میتونه به این در واقع این تصور پیش بیاد که ایشون میخوان ازدواج کنن یا حتی ازدواج کردن و این به نفع کیس شما نیست. Yeah, makes sense.
Yeah, okay. What other questions?
The next one is that I'm an American citizen and I have applied for green card for my sisters. All cases have been approved and are in embassy. At the time of application, all of them were single, but now they are married and have children. The names of spouses and children are not in the I-130 form, and I have never done anything about it. Should I contact embassy?
Yeah, so earlier I said that you shouldn't get married for your immigration case, but it depends on your case type. If you are a child and your immigration benefits depend on meeting the definition of a child, then you can't get married, because if you're married, you no longer meet the definition of a child. But what if your case is based on being a sibling? If you're a US citizen, you can petition for your brothers and sisters. Your brothers and sisters can get married, but it gets even better. Your brother and sister's spouse can be included as a derivative in the case. And children of brothers and sisters can be included as derivatives in the case, as long as they meet the definition of a child. This is all well and good, but these cases take many years, 8 years, 10 years, 12 years, 15 years, up to 30 years if you're the brother and sister of a Filipino petitioner. People change their lives during this period of time. And the question is how to update the National Visa Center with that information. Well, I think you should contact the National Visa Center and provide them with the information, show them that you're married, the marriage certificate, each person will need to fill out a new application, a DS-260, but the National Visa Center is where that takes place.
Perfect. دوستی پرسیدن که ایشون سیتیزن امریکا هستن و برای خواهرشون درخواست داده بودن، کیساشون همه تایید شده، منتظر وقت مصاحبه هستن و زمانی که براشون درخواست دادن فرم I-130 رو که پر کردن اینها مجرد بودن، ولی الان ازدواج کردن و بچه دارن. آیا لازم هست که به امبیسی اطلاعاتی داده بشه؟ پاسخ این هستش که بله، شما باید marriage certificate، سند ازدواج و اطلاعات در واقع تغییر وضعیت تعهد رو اعلام کنید و هیچ مسئله نیست که اونها ازدواج کردن یا بچه دارن. بچه ها باید قانون در واقع چایلد رو رعایت کنن که مجرد باشن و زیر 21 سال باشن. Makes sense.
All right.
Okay.
Let me answer some more questions from YouTube, TikTok, Instagram, LinkedIn, and all the other social media. Here we have it says here, I just got approved for global entry. Can I use my global entry card as evidence of status if I drive through CBP domestic points and I don't have my green card with me? That's from Roy on YouTube. And the answer is no, you cannot. You have to have your green card or the equivalent with you. Global entry is not sufficient. Here is another question from Yasser on YouTube. Sir, I filled out my I-130 for my sister. I got her approval and her invoice number, and she's at the interview stage in Kabul, Afghanistan, and she isn't feeling well. I don't know what to do. I work for the U.S. military. Boy, Yasser, that is a difficult question because I cannot tell you how hard it is to get interviews. And I would be very reluctant if I were you to cancel or reschedule that interview because it could be months or years, many years until you get your interview rescheduled. If your sister isn't feeling well, I would consider dragging her to the interview even if she's not well. But if she's extremely ill, hospitalized, has a communicable disease and cannot go, then but it's a very agonizing decision. So consider that. But I would try to go to the interview. Maybe you could translate that, Halle.
Yeah, perfect. متاسفانه یکی از دوستان به مشکلی خوردن که در واقع از دوستانی که عضو پرونده هستن بیمار هستن و در مورد شرایط خاصشون پرسیدن و آقای جاش توضیح دادن که بهتره به جای اینکه وقت مصاحبه رو دوباره زمانبندی کنیم و ریسکیجول کنیم، بهتره که در صورت امکان ایشون توی مصاحبه حضور داشته باشن مگر اینکه شرایطشون خیلی حاد باشه. It's so sad and unfortunate. Yeah. You know.
By the way, for our friends on TikTok and Instagram, you can't see right now, but I have Halle with me. She helps us. We have a special Telegram channel where we share content that we don't share anywhere else, and this is intended for the Persians and people from Iran, it's wonderful to have her here. This is a group of people that's incredibly important to me, and really all people are important to me. This is a group of people who we've worked very closely with this community, and we're grateful to be part of. I'm going to take some more questions from TikTok here. How long does it take USCIS? This is from Chris Folks. Thank you for joining us, by the way. Thank you for everyone spending time with us. How long does it take USCIS to notify you that they've received your I-601 waiver packet? So essentially what USCIS does when you file any type of immigration case is they receive it, they process it through a mail room, and then they send you a receipt notice. And that process usually takes 6 weeks, tops, 6 weeks. So there's that. Let me see if I have some more questions. Shahid Zaman Khan is here. Pakistan squash legend, friend of mine. So grateful to have you joining us. It says here, this is from Kells. It says, I'm a J1 visa holder. My boyfriend is a U.S. citizen. Can I apply for a change of status to a fiance? That's a very good question. And the answer, as always, is it depends. I would need to know a lot more information about your facts. But if you are in the U.S. on a J1 visa and you get married to a U.S. citizen, there is a possibility that you could, what's called adjust your status to a green card through an I-485. The fiance visa is almost exclusively used for people who are outside the US. Conceptually, I mean, technically you could file a fiance visa within the US, but it would make no sense to do so because it's essentially only a visa. So, Kels, if that's your situation, you should contact us and we can schedule a strategy session with our team, and we can definitely give you some advice and help you reach your goal. And also, congratulations on getting engaged if that's what's headed. Can a green card holder petition for an immigrant child under 21? The answer is yes. Yes, you can. Let's see. Here's another one. Sweet Shaw on TikTok. Do you have to file an I-45 with the I-360 to get prima facie, or can you get it with the I-360? I-45 is not required. You can get prima facie determination by just filing that. Let's see. What other questions do we have? Maybe people could put in the comments. I'd love to hear you put where you're from. I mean, I'm here in Los Angeles, and Helen is in Orange County. Where are you guys from? Where's everybody from? Please let me know. Put it in the comments below.
So many people are struggling to join their families in the US, and I just want to show empathy to them. And I think when you should wait, please wait. And when you have an option like mandamus, it's very important to take action and don't miss your opportunity to join your family faster and sooner.
Yeah. When it comes to empathy, let's be honest. Let's be frank. Immigration is not easy. It's hard. It really is. The system is complicated. It's, in my opinion, unfair. The process is getting harder all the time, and it requires a lot of patience and tenacity. It's not easy, and certainly want to be as resourceful as you can. And that's why I'm glad that everyone out here is following me and spending time with this live broadcast. You're getting educated and you're being aware of what's going on. Let's take a question from Facebook. Here we have Zahin Asbad Chowdhury. What do you say about family immigrants, I-130, who are aged out for the visa bulletin, no movement for the last few years? Is this humanity? No, it's not. It's very unfair. It's very unfair that a system would remain stuck in a way that would disqualify someone who's tried to do the right thing. That's totally unfair.
Totally.
That's totally unfair.
Because, I like this topic because my case was F2B, and when my mother applied for me in 2010, I was thinking maybe in the next 5-6 years I will get my visa and then green card. But I was waiting for more than 11 years. And
11 years. You waited 11 years.
Oh my God, that was really unfair because I couldn't see my mother, my sisters, and the other hand, I couldn't get married. And I couldn't understand what is the rule, what is the concept. It's not reasonable and it's not fair. And
it is. I think the U.S. immigration system is absurd. I've spent more than 20 years as an immigration lawyer. It's very unfair. It's, but you have to wait. Look at this. Come here. Come here.
Oh,
I have a guest here. Come here.
Really?
1 second. That's fine. Come here. Oh, he's a little camera shy, but I have my son in my office today. He's homesick.
Oh my God.
He's getting extra iPad time, and he's eating all my gum right now. Let me just take a question from Amir Hussein Musavi. Josh, would you consider to be appropriate filing a writ of mandamus after having an H-1B and undergoing administrative processing? Hell yes, you should. I think the mistake is waiting too long. If you keep waiting and waiting and waiting, you might wind up losing your job over this. And we get great results from people who've had delayed H-1B visas. So you should contact us and we can help you out. Here's a question from Facebook. We are F4 visa candidates. NBC sends us a case creation letter for submission of IB visa civil documents in 2020. We submitted all the required documents and fees, and after that, the visa bulletin has not changed for 18 months since the time of Corona. Unfortunately, that's why our priority date is not current. We are still waiting for the interview for the last 2 years. As a result, we are getting aged out for the visa bulletin. No movement. Will not get CSPA benefit for the visa delay for this reason. It goes on. Listen, if that's your situation, my heart goes out to you because that's a very cruel result. You're waiting and waiting and waiting, and when you age out, you're disqualified. So I get that. And if I were the president, or if I had the power to do so, I would create a new law that would help everyone in that situation, give them the chance to reach their immigration goal. That would be the only fair thing to do. But one thing that I can't do, and I want to be clear about this, I have no ability to help people. As much as I would like to, I have no ability to help people who are delayed because their cases are not current in the visa bulletin. The visa bulletin is something beyond the scope of my control. There's no lawsuit that I can file that can make the visa bulletin go faster. The visa bulletin is an animal that is outside the scope of anyone's control. You have to wait for it to be current. It's cruel. It says here from Imran Ahmad Roman, children are aging out, but they are not getting any benefits. It's not a benefit at all because American citizen, the filing chart is count F4. We have no fault here. Please do something. Imran, all I can do is express my sympathy for you, my empathy, how unfair that I think this is. But there's nothing that I can do if you're F4 and the visa bulletin is stuck and you're aging out. It's just an unfortunate situation. It's very cruel. Other immigration benefits. Consider, if possible, consider the visa bulletin or a green card through marriage, or look for another immigration option to the US or to another country. But if you're aging out because the F4 category is stuck, there's no legal solution that I know of that can help you reach your immigration goal, unfortunately.
It's unfortunate, yeah.
It is.
Pardon?
It is.
Yeah, of course. Yeah,
What other questions do you have for me?
The next question is that I'm a US citizen and I'm going to bring my parents and my sister to the US. She is 24 years old and she is single. Should I apply for my parents first and then apply for my sister? Or it's better to apply for all of them at the same time? Which one is
Boy,
best?
I love this question. This is such a great question. And this is going to take me a long time to answer because I have a lot to say. So the person's a U.S. citizen. They want to apply for their mother and their father and their sister. Okay. How do they do that? Okay. Here's the answer. If you apply for your sister, it's going to take 10 to 15 years. Okay. So the sister is going to take a very long time. If you apply for your parents, it's going to go relatively quickly. It might take a year or two, right? So if you apply for all of them at the same time, your mother and father will get approved. They'll get their visas. They will be required to leave their home country, to move to the U.S. and to live in the U.S. physically and permanently. But your sister will be left behind. And your sister will have to live in your home country for another decade or so, indefinitely, until she reaches her immigration goal. So you are in the U.S., your sister's stuck in your home country, your parents are with you in the U.S. Is that a scenario that works for you? You have to ask yourself. And if it doesn't work for you, then your parents have to continue living in their home country for a long period of time. And then you could wait until your sister gets her green card, which will take 10 to 15 years, and then get your parents. So those are some things to consider. Holly, maybe you could translate for us.
Sure. دوستان پرسیدن که ایشان میخوان سیتیزن امریکا هستن و خانوادهشون و خواهرشون رو میخوان بیارن امریکا. پرسیدن که آیا بهتر هستش که برای همهشون همزمان درخواست بدن یا اینکه اول برای پدر مادر درخواست بدن و بعد خواهرشون رو بیارن امریکا. پاسخ این هستش که اگر که همزمان براشون درخواست بدین، پدر مادر شما سر کارشون درست میشه ولی خواهر شما توی ایران میمونن. و اگر هم بخواین صبر کنین که همشون با هم بیان، باید خیلی منتظر باشین، بیشتر از 10 سال، شاید هم 15 سال طول بکشه. And what about if he brings their parents to the US and the parents after getting green card apply for the child?
Yes, that was the next thing. So then the people say, okay, what if I bring my parents to the US and then the parents apply for the kids? That's fine, but that could take 10 years. It could take 8 years. And sometimes the parents we have in this situation, sometimes the parents are in their 70s, and I've seen situations where the parents pass away and then the immigration case goes down the drain. So you should file a case for your sister, and then I think you should wait until your sister gets approved and then apply for your parents. Or maybe you can live with the fact that your parents are going to leave your sister behind. But you have to be aware that there may not be a solution that's going to work perfectly in your situation. Also, I'm getting a lot of comments from people about F4 visa delays, doing a lawsuit. It's not their fault. I have full sympathy for you, but there's nothing that I can do to help.
Yeah, unfortunately, it's too long to bring a brother or sister to the US. Actually, I don't know what to say. Just let me translate the second part of your advice to our friend. در واقع شما گزینه‌ای که دارید این هستش که بتونید برای پدر مادرتون درخواست بدید، این دوستان تشریف بیارن امریکا، گرین کارت رو بگیرن و بعد برای خواهر شما درخواست بدن که چیزی حدود 8 سال تا 10 سال ممکنه که طول بکشه. Sounds great. And let me invite our friends to our website. If you have a delayed case, if your case is stuck in administrative processing, you can go to jgoldlaw.com and tell us about your case, and we can evaluate your case and see if we can help you, and maybe you can get your visa faster.
Yeah, if anyone needs help with a marriage green card, with any kind of with naturalization or any other immigration scenario, you can contact us in the link in our bio on my website, which is www.jgoldlaw. All of those places. You can find me on every social media channel. Getting a lot of more questions about F4 visas. It's just sad scenario. Again, nothing we can do if people have aged out because the visa bulletin is stuck. How long after a 3-year overstay will you be allowed back in the U.S.? That is a question that depends on the facts of your case. If you're looking for a visitor visa, you might not get a visitor visa. It might be very difficult. The technical ban of 3 years is only one of the many hurdles that you face. It's difficult. What other questions do you have for me, Holly?
Yeah, of course. The next question is that for one of our friends, he said, I had an interview at the Yerevan Embassy for F2B case, and I was placed in AP. Since there is not any maximum time to be cleared, my partner and I are going to meet each other in Dubai. Do you think it would be risky for us?
So someone has an F2B case. That's a case based on marriage where the petitioner is a green card holder. Is that right? And they had an interview. They were placed in administrative processing. Is that correct?
Yeah. They should be unmarried until getting green card or visa. And he said that because the AP
Wait,
is
wait. Is this a fiance visa case?
F2B, unmarried adult child over 21.
Unmarried adult child. And the person wants to meet with their
Yeah.
boyfriend or girlfriend. I think a meeting would be fine. What I don't like is a formal engagement, an engagement party, anything that suggests that you've taken concrete steps towards getting married. That is something that I think could be misconstrued as actually getting married. So that's what I wouldn't be in favor of.
Perfect. Let me translate that. دوستان پرسیدن که ایشون توی سفارت ارمنستان اینترویو داشتن و کیسشون F2B هستش با توجه به اینکه برای ادمینستریتیو پروسسینگ مدتی ماکسیمومی وجود نداره. ایشون گفتن که خودشون و پارتنرشون قصد دارن که توی دبی همدیگر رو ببینن. آیا این میتونه براشون ریسکی باشه؟ پاسخ این هستش که اگر که به شکل رسمی نامزد نکنن و در واقع مهمانی نامزدی نباشه و فقط هم رو ببینن، به نظر نمیاد که مسئله پیش بیاد. ولی در هر صورت توصیه کلی این هستش که تا زمانی که گرین کارتتون رو بگیرید بهتره که شرایط پرونده که مجرد بودن هست رو رعایت کنید. Sounds great. Good to know that. And you know, I think as you mentioned, it's worth it. And I was waiting and now I got married. So if you
Congratulations
wait,
again. Recently married.
if you wait like me, you will get married and you will have a great a life here, join your parents, and everything could be much better.
Yeah.
Yeah.
Yeah, well, this is very interesting here. Let me know if you have more questions.
Yeah, of course. The next one is that I'm 31 years old and my father applied for me 10 years ago when he was a green card holder. Now he became a US citizen. I'm not sure if I should request to convert my case to F1 or opt out of the conversion.
Okay, yeah, I've answered this question many times, but I'll answer it again. The question is, someone is the beneficiary of an immigration case where their father petitioned for them and the father was a green card holder when the petition was filed, right?
Yes.
And since that time, the father has become a US citizen. And the question is, should the case be converted to a different category or not? What should the person do? And the answer is that there is a flawed premise in the question. And the flaw is that the person thinks that they have an option to convert or not convert the case to a different category based on the fact that the petitioner is now a US citizen. It doesn't work that way at all. When the petitioner becomes a US citizen, by operation of law, the case is automatically converted. Okay? Now people are like, well, wait a minute, how do they know that that my petitioner is a US citizen? They know. They have computers. It's all sorts of they know. It doesn't matter. There's nothing you need to do. Your case is going to be converted. And sometimes that can have horrible consequences that'll render an approvable case to be not approvable anymore. But nevertheless, it's an operation of law, not something that you do or don't do.
Yeah, so is there an option to opt out because of the visa bulletin and says maybe because I'm current in F2B, I want to remain my case to be F2B instead of F9?
No, there's no option. You can't say, well, I'm going to decide which category I would prefer, and that's what I'm going to do. If you want to stay in the category for permanent resident petitioners, then the petitioner should not become a U.S. citizen. That's the solution. But if you just file paperwork and you don't know what the hell you're doing, and you have all these, and you're operating without an attorney, without advice, you end up, I've seen situations where people ruin their lives over this. So get informed, people. Know what's going on.
Sure. دوستان پرسیدن که ایشون 31 سالشون هست و پدر ایشون برشون اپلای کردن 10 سال پیش که گرین کارت داشتن، الان ایشون سیتیزن هستن و در واقع ایشون مطمئن نیستن که درخواست بدن که کیسشون تبدیل به F1 بشه یا F2B باقی بمونه. آقای جاش توضیح دادن که هر زمانی که پیتیشنر شما سیتیزن بشن، در واقع کیسشون به طور اتوماتیک از F2B به F1 تبدیل میشه و اینکه میپرسن از کجا متوجه میشن. خب اطلاعات سیتیزنشیپ توی اینترنت هست و به این اطلاعات دسترسی دارن. به همین خاطر ایشون پیشنهادی در این باره نمیکنن که کیستون رو بخواین F2B باقی بمونه. Okay, sounds great. And yeah.